The state has finally closed its case in the Senzo Meyiwa murder trial. Hello and welcome to this edition of Inside the Courtroom, the Senzo Meyiwa murder trial wrap. I'm Linda Mnisi. Now, it has been a long, turbulent ride for the state, and it has finally reached the end of its case. Now, in what was meant to be a short week in the trial, this week was marred by complaints of torture coming out of the Kgoshi prison. This is where the accused, Bongani Ntanzi, Mthobisi Mncube, and until recently, Fisokuhle Ntuli. The week started with the alleged gunman, Mthobisi Mncube, refusing to come to court following a directive to bar shield pads usually placed under leg irons for the accused.
As a court case, my lord, case number 3, Mr. Mncube is not yet here. We're informed that there was an issue this morning about the removal of what they call pads that they put around the ankles to minimize the impact of the leg irons with the ankles.
Why should they be removed? I don't know.
The area commissioner issued out that instruction. We don't know exactly what is the reason for that.
They must be removed from each and every person who has those pads.
Yes, yes.
On his or her body.
Or on the ankles, yes. So on the leg irons,
yeah,
around the ankles. But we are told just before we resumed that the situation has been addressed and accused number 3 is en route to the court. We just wanted to explain the situation to the court for the delay in resuming this morning's proceedings.
The judge probed the extent of this directive.
Are they having pads at the moment?
Well, as far as I was told, my lord, they don't have those pads.
All of them?
Yes.
Is it a general application for the rest of the country?
Yes, apparently that is an instruction that was issued, but I think the accused themselves can confirm that, but that is what was communicated, my lord, that they don't have pads on the leg irons.
May I confirm with accused number 2?
Yes.
My lord, all the accused here are having their pads on.
They are having their pads on?
Their leg pads, yeah, those items that the state is referring to. They do have them.
The head of the BMAC Center of the Correctional Services informed the court about the directive, which had now affected court time.
The instruction was based on the escape that took place at Bavianspoort, where the offender had the sponge and the cuffs on top. The offender took out the sponge, and the cuffs could easily get out of the leg, and the offender hit the official with those cuffs, and he escaped. Up until today, he was never found. So we only got instruction from our area commissioner as Kgoshi that we should not allow offenders to put in those sponges when they come to court.
So did you explain to your inmates at Kgoshi?
Yes, I did explain to offender Mncube at the center. I think it was last week, if not last week, to say this is the instructions, and the response from him was that if he's not going to be allowed to put the sponge on his leg, he won't go to court.
But Mncube's lawyer was not having it, even giving the court an ultimatum.
Accused number 3 is in pains.
He's what?
He is in pains. Yes. He is unable to concentrate. I'm unable to receive any instructions from him. If the court were to insist that despite this gross violation of a human right that has been subjected to, that this court says he can continue, I wish to inform the court, my lord, and with due respect, that I do not want to be seen to be part of that violation of a human rights, of the right of Mr. Mncube when attending this trial, because he's not only been foot cuffed, he's also been handcuffed. Mr. Matlala does not address the issue of him being in handcuffs when his colleagues or when the other accused persons are not cuffed on their hands.
Accused number 5's lawyer told the court that the accused should not be penalized for the escape of another inmate. This is an inmate who is kept at a different facility, Pavian Sport in Pretoria.
I submit that even if it's the reason that Mr. Ntuli should be punished or penalized for someone who escaped from another prison, my lord, that communication I have requested as the legal representative of accused number 5. I've requested that communication for the area commissioner from Mr. Matlala to say, give us the communication, whether it's an internal memorandum, whether it's an email, the instruction that has been given, so that we can be able to apply our mind and take the instruction, because someone's right is affected by such decision by the area commissioner.
So are these shield pads a right or a privilege?
We just confirmed this with Mr. Matlala that the use of sponges, it's not ordained by correctional services. It's something that inmates themselves make. Once again, my lord, it will boil down to, is it a right, is it a privilege? And I think perhaps it's a matter that should be decided on affidavit, keeping in mind the discretion that an area commissioner has on such matters.
An agreement was later reached coming from the highest office of the Correctional Services.
Correctional Services has decided to restore the ankle pads, and they're doing so, my lord, in the interest of progress in the case. As we speak, the accused are wearing those pads.
The day was lost to this tussle as the accused indicated that they could not proceed due to the pain that they were experiencing. But the issues did not end there. On Wednesday, accused number 5, Fiso Ntuli, also came with another complaint, this time of torture, which Ntuli says started during recess and led to his removal from the BMAX facility to the maximum security center of the Hoshimampuru prison. This necessitated calling the head of the CMAX center.
So, but he says somebody deprived him of the sheets and the blankets. And he calls the name of Lekwa. Actually, the word he uses, he was tortured.
My lord, each and every offender is entitled, it is his right to have blankets and the sheet. So we cannot deny him as such.
But I'm told he was transferred to CMAX or what?
Yes, my lord, to CMAX.
He's transferred to CMAX.
On the 9th.
On the 9th
of July 2025, my lord.
9th of July.
Correct, my lord.
What was the reason?
The reason was that he was found in possession of a cell phone, my lord.
So he was transferred to CMAX on the 9th?
On the 9th. The cell phone was
July.
found on the 8th. Yes.
Hello?
The cell phone was found on the 8th of July. Then was transferred to CMAX on the 9th July 2025.
The raid happened on the night of the 8th of July, and present was the National Commissioner for Correctional Services, Mahoti Tabachale. Ntuli denied the claims made about him being found in possession of a phone, claiming his move to the CMAX center was a decoy.
The people from the CMAX, they are covering up for themselves by sacrificing with me. The person who was found with a cell phone in CMAX, it was David Ramahale, and then he was then removed from CMAX. They took him from CMAX, and then they brought him to BMAX, where I was placed at. Now that they took away David from CMAX to BMAX, they took him before his time came, and then they replaced him by sacrificing with me.
He also detailed the alleged torture.
From the 9th, he was placed to the CMAX till today.
Do you have problems at CMAX?
Yes, my lord, I do have quite a lot of challenges, no problems.
What are they?
He's being tortured. They know that he mentioned that he is denied to make a cell phone or a telephone call, and then they took his blankets, Then they make him to bath with cold water.
Noting he had no authority to interfere with the work of correctional services, Judge Ratha Mokgoatlheng gave an order that he be moved to local prison when Ntuli says he will not experience these challenges. This is the same center that accused number 4, Mthokoziseni Mapisa, is kept. The judge said he made this order in the interest of this matter proceeding without any delays caused by the issues of detention. Correctional services reacted.
We can confirm as a department that inmate Fisokuhle Ntuli was found in possession of a mobile phone, an item which is strictly prohibited within our correctional facilities. He was questioned and he admitted to ownership and the usage of that particular gadget. It was therefore necessary that inmate Ntuli be transferred to CMEX due to the reclassification that had to be conducted at the end of that particular search operation.
Area Commissioner for Kgosi Mampuru's management area informed the judge that the accused's claim was untrue, but the horse had already bolted. The judge advised he instead brings an application to rescind his ruling. For now, Ntuli remains in the maximum facility of the local prison. After the break, the state closes its case. Don't go anywhere. Welcome back. Now, the state rested its case on Thursday after a tumultuous 3 years of trying to prove the allegations against the 5 men accused of killing soccer star Senzo Meyiwa. I know we're all breathing a sigh of relief because this signals that we are halfway through. Now, the state handed up an updated list of exhibits on Thursday before officially wrapping up its case. Take a listen.
On that point, my lord, that concludes the leading of the evidence for the state.
Okay.
And we close the state case. It's precisely 3 years since the state started leading evidence, and the state now formally closes its case.
State case closed. Yes.
What does this mean, you ask? Well, the ball is now in the defence's court, and they can either file an application in terms of Section 174 of the Criminal Procedure Act to have the case thrown out on grounds of no reasonable prospects of a conviction, or they can simply open their case and call their witnesses. So they have made this decision. Take a listen.
My lord, we've got instructions from our clients that we need to bring an application in terms of Section 174, which instructions we communicated to the financer of their defense, who is the Legal Aid South Africa. And Legal Aid South Africa then requested us to request an indulgence from the court to have the matter stood down for a week or two.
Joining us now is our legal analyst, Melusi Ulu, to help us unpack where we are with this case. Melusi, thank you very much for your time and for always availing yourself, to unpack this marathon trial. I want us to take a look at the complaints by the accused. The judge has clearly said he has no authority to interfere with the work of correctional services, but made an order for Ntuli in the interest of, the matter proceeding without any interference, and said if there is a problem with this particular order, a rescission application can be done. Now, does a rescission application apply here, given that there are no parties that filed papers, the submissions were also not made under oath, and that the merits of the complaints were not dealt with? How would that rescission application work?
No, I don't think it will work properly because it's not an application that was made. But I think what is important is that the Department of Correctional Services and legal representatives and all the parties involved, including the judge, must just work together to make sure that the accused, at least they are given a proper way of presenting themselves in court and not having any problems. Because at the end of the day, they must be in a good condition so that the matter can proceed properly.
Do you think this case in particular hinges on whether or not Kelly Kumalo, ordered the hit? Because from my understanding, it seems the allegation here is that the 5 accused participated in the murder. Is that not the allegation? Will the court not look at, evidence based on the allegation that the 5 accused allegedly participated in the murder of Senzo Meyiwa?
Focusing on the accused, I believe, yes, that was their belief that they are part of the murder. It's just that not to say it can't be proven. I'm saying if you are saying these 5 are assassins, then why not arrest the person who sent them if you do have information? And if you don't have the evidence at that point, then investigate further. I mean, there's an instance where there's a warrant of arrest that was issued, but it was not signed by NPA. So it makes it look as if they did not have that, desire to go further. But I agree with the fact that at the end of the day, these accused are charged with murder, and that's what we should focus on, so that justice can be obtained for Meyiwa's family and Senzo Meyiwa.
I know you've mentioned the issue of the confession statements, but when we look at the evidence of, Constable Sizwe Zungu, who placed the accused in Phosphorus in the vicinity of the crime scene on the day of, the murder of Senzo Meyiwa, you look at the evidence of the gun, you look at the evidence of descriptions that were given even by witnesses who deposed statements, like Thabang Makeleni, who we know has since passed away. When you look at the entire evidence of the state's case, do you think that at this point there is a prima facie case against the accused, given that the state's case is largely based on circumstantial evidence?
Yes, look, the confessions, like I said, they could be a problem for accused 1 and accused 2. When it comes to Zungu, yes, he placed them there on the scene, but there are some questions which I think they can be challenged when it comes to Zungu. There's questionable issues there. Although I think if they don't get Section 174, the defense must ensure that they get Sizwe's father, or Absalom Zungu, who has stated that this theory that Sizwe, this evidence that Sizwe was there and he saw the accused and so forth, he's of the view that he was lying when he said it, because he also tried to involve him in that, in mentioning it. Well, that's what the Absalom Zungu is saying. I think that should be tested and they can use it.
The reasonable doubt question obviously is something that will only be determined at a later stage. In the instance of this 174, Melusi, what do you think are the reasonable prospects of success? What is the legal test here, and what is the defense likely to look at when it aims to prove that there isn't any prima facie case made out against their client? Their client cannot be put in their defense given the state that, the evidence rather that the state has led. I mean, I've already counted the issue of the gun. I've already counted Sizwe Zungu's testimony. I've already counted quite a number of other things and other elements that the state has led. But what are the prospects of success for this application?
Well, what does Section 174 say in the Criminal Procedure Act? It says that, and I'm paraphrasing, that you can apply for it if you are of the view that no reasonable person can convict the accused based on the evidence. There's no evidence that a reasonable person will convict based on what has been presented. So at the end of the day, it must be proven, or there must be a reason to believe that the evidence that has been placed there's no evidence at all that you can contest the test that is there. So it's not a beyond reasonable doubt test, but there's no evidence at all at that stage. So you've mentioned those issues that you've mentioned about the gun, the people in the house, Sizwe Zungu and so forth, because the aspects of Sizwe Zungu, there's no other evidence that I believe can test it unless they bring his father. So I believe with that, let's say there is something that tells me that I think for accused 1 and accused 2, Section 174 will be difficult, because when you have a confession that has been admitted, and it is saying, I did this and I killed this person, I was involved in the killing of the deceased, and it's part of the evidence. for Section 174, it's very difficult to succeed unless that confession is not admitted. Then at least you can have a room to move around.
Okay, so calling other witnesses, if this 174 application does not succeed, the defense can call, its own witnesses, and this includes the people that they've been asking the state or pressuring the state to call. I'm talking about Kelly Khumalo here. I'm talking about Longwe Twala. You've just mentioned the name of Absalom Zungu, who we've been seeing on social media platforms and in other media reports, indicating that he is, telling a different story. Those are the people that the defense can call, right, in their own case. But when you look at, for example, the statement of Kelly Khumalo, she says there were intruders in the house. Would those people be able to assist in the defense's case, given, of course, that right at the top is the name of Kelly Khumalo? And I'm saying this again because there's been a lot of pressure, even from the public, asking why is she not being called? But if she's called now by the defense, will she assist the defense?
She will not be a witness that will be in support of the defense for obvious reasons. She's the person who was involved with Senzo Meyiwa, and then with that, she can't be supporting the accused who are accused of killing the person she was in love with at the time. So I don't think she'll be a witness who will be helpful or supporting their case, but she's a witness that they might end up applying to be a hostile witness. But the point is, there's evidence that needs to be discussed. The first one is, what did she see? She will obviously then have to describe what she saw based on the docket copy or the statement that she made. What the states tried to do when they left out Kelly Khumalo was to say they might not have enough evidence, but they'll just focus on what they have. So it will be interesting if they bring it, but she will be a difficult witness. I think that's what I want to conclude with.
All right. Thank you very much for your time. That was Melisi Xulu joining us for some analysis. They're saying that Kelly Khumalo could be a hostile witness and might not necessarily assist the defense case. Now, Xulu, they're helping us, just unpack and understand where we are and what, of course, to look out for when, of course, that application for a discharge comes, and if it will come. After the break, the court of public opinion has been a buzz from day one. So we want to hear what you at home have to say. Stay tuned. Welcome back. You're still watching Inside the Courtroom, the Senzo Meyiwa murder trial, and I'm Linda Mnisi. Now, years after the soccer star's murder, the Senzo Meyiwa murder trial continues to grab the attention of the public. Everything and everyone involved in this matter is under scrutiny. The case has birthed a community which includes, podcasters and social media commentators who break down the case in live discussions happening on social media every single day. But I'm joined now by podcaster Bongani Masugu as well as social media commentator Mabelane. Gentlemen, thank you so much for your time. Good to reconnect with you after, of course, we did that 1 year, or rather that 10-year wrap of the murder of Senzo Meyiwa. So I bring you back again to discuss the end of the state's case. Bongani, I'll start with you. Your viewers largely believe that the state arrested the wrong people here and have had rather strong views about the evidence that the state has brought. Talk to us about what your thoughts are on the state's case now that it's closed.
Thank you very much, Mr. Linda, and welcome. Thank you for welcoming me. And I think we have all witnessed or see what happened. I strongly believe that we still don't have the right people. Up to today, I strongly believe we, when I say we, I mean, what was happening in court. Yeah. I don't think today, as of us standing now, right here, we can convincingly or confidently say we have presented enough evidence to convict the accused.
Okay, I'll come to you now, Mabelani. You know, you're known on the social media platforms as official minister, and your audience with Bradeni dissect this case every night. What are your overall impressions? I know you may have had a discussion on Thursday after the state wrapped up its case, but what are the views that are coming from yourself and largely your audience?
Yeah, thanks, Linda. The views are very clear in terms of whether they've got the right persons or not. We believe they've got the right people. These are the 5 accused who have contributed into the murder of Senzo Meyiwa. And we are saying this based on the evidence that is led before the court. Because Muzi Sibiya and Santi Sontanzi, they've made confession statements, which the court has ruled that they were made freely and voluntarily so, made while they were in their sober senses. So from that perspective, they have pretty much convicted themselves. The evidence is before court is admitted. Accused number 3, his firearm is linked to a projectile that was picked up by Musia in 2014. There is no question about that. And even in 2015, he was busy engaging police officers whether he is implicated or not, according to Mnisi. Accused number 4, he has told us through Zitulele Ngumalo that I've been with accused number 3 all the time on that particular day. So if those who were in the house places move inside the house of the Kumalos, by inference, he must be positioned there. And then accused number 5, who is Fizo Kutlentuli, who is Umtitieli Wezingabi, who organized the whole thing. There is a telephone link that connects him with Kelly Kumalo. And that evidence is not disputed, Linda. Why am I saying so? We know in legal terms how do you dispute the expert witness. You don't just argue and say, no, it's not correct. You call your own witness to come and dispute that particular evidence. So based on what I've said, we believe that the Senzo Meyiwa family is going to get justice because the people who have killed Senzo Meyiwa are before court.
Interesting views there, gentlemen. I'm interested because you know, Mabelani has gone into the evidence and why they believe that, you know, these are the right people. Bongani, talk to us about the evidence that you think, you know, really exonerates the accused here. I know the issue around, you know, the DNA is something that is spoken about largely, but we're also looking at the fact that this is, you know, circumstantial evidence that has been brought. What, in your view, exonerates the accused from your viewpoint?
All right, I will start with what have just happened recently. Mr. Absalom Zungu, I cannot wait to see how the defense is going to handle that situation. Well, you must remember that I'm not a lawyer, but look, just to lay this basis, we know, we've been told in court that the state has the prerogative to prove its case beyond reasonable doubt. There should not be any doubt in the state's case, right? So just this aspect alone, if you bring Absalom Zungu, who has already deposited an affidavit, who's just waiting to be called in court, we're just waiting to hear if that is going to happen. That alone, I'm not going to, we can go on, but that alone tells you there will be enough doubt to acquit the accused. Let me quote. In the case between the state versus Mr. Timothy Omotos, the judge said, the state has failed to prove its case beyond reasonable doubt. The judge turned into Omotoso and said, you, Mr. Omotoso, neither did you prove your innocence. I'm not convinced that you are innocent. However, the state did not prove its case beyond reasonable doubt. Now you talk to me about the DNA test. That was enough to poke doubts that the accused are not the right people.
As it stands, what we know is that they've been admitted as evidence until such a time that it is thrown out at the end of, you know, the case. I'm interested in also the point that you raise about Absalom Zungu. I know you're probably referencing an interview that he did, but that interview is not before court. Don't you think it would be in the interest of the defense to then call him to the stand, because what he says to the media cannot be translated into court record. He needs to come to court and say it to the judge.
110% correct. Listen, if he had said this without taking a legal step, then I wouldn't even quote this here. But for the fact that he has already deposited an affidavit, that's a legal step for me. And we all know what an affidavit does. It stands before court. So he has already deposited an affidavit at Newcastle Police Station, if I'm not mistaken. We are waiting to see if the defense will call Mr. Absalom Zungu. But the affidavit is already there. That's a procedure, right? He followed the right procedure. That's the word I wanted to follow. But if it was just an interview like this, then I wouldn't have counted it.
Yeah. Interesting that you mentioned an affidavit, because that affidavit he would also have to bring to court. As it stands, it is unknown because it's not part of the court record. I'll come to you, Mabelani. You mentioned the issue around the defense not challenging really the evidence of the gun. We know that the defense called its own witness, or rather did not call him to the stand, but got the opinion of their own expert who says he disagrees, to a certain extent with the results of this particular gun. But also, Bongani raises the issue of, Absalom Zungu and the interview that he did, saying that it really creates doubt. But like we've just discussed, it has not been presented before court. So it's pretty much something that, does not exist before court, which is the most important platform here. He also speaks about the issue of the DNA. And we know that there are certain people who it is not disputed that they were in the house, but their DNA was not picked up. Does that throw the spanner in the works for possibly someone who may want to rely, if the defense perhaps wanted to rely on this particular, DNA results?
Yeah. Thanks, Linda. You see, the DNA issue for me is neutral, and I'll tell you why I'm saying it's neutral. It doesn't have any weight in this case. Let's take Tumelo for an example. Tumelo was having those crashes all day. What does the DNA report say? The DNA report says Tumelo never touched those crutches, so they don't belong to him. There is no his DNA on those crutches. So if we were to use the logic that Bongani uses, it means Tumelo never touched those crutches. So you cannot really infer from that perspective that because the DNA is not sufficient and then you ignore everything else. Hence, I'm saying that point is going to be easily argued. On the point of Absalom Zungu, it is very shocking why Bongani decides to rely on that affidavit of Absalom Zungu and never rely on the affidavit of Absalom Zungu that is before court. We're talking about the matters that are before court, not the matters that are being published somewhere else in social media. We are saying the affidavit of Absalom Zungu is before court. It has been commissioned. And in court, as we speak, what does the evidence say? None of the defense lawyers, none of the accused has ever disputed that the affidavit that Absalom Zungu commissioned with Brigadier Gininda is in question. So as it stands, we only have one affidavit before court of Absalom Zungu. The affidavit we don't know. We can wait and see if it will ever see its day in court. But to conclude on this point, Linda, let's take it slowly maybe and say, what does the affidavit of the Absalom Zungu has to this case? It does nothing. Whether it exists now or it doesn't exist, with the case before court, it does nothing. It was only helpful for the investigators. It is not evidence before court. The state has already made it clear that we are not going to rely on that because the state has got the duty not to lead hearsay evidence. However, the investigators have relied on it to break this case. Now, on the confession, Bongani mentions that the confessions are not, if they are true, why are they not the same? It is common a thing in our law that you will find those people who are implicated, even when they make up confession, they underplay their role or they exaggerate their role. And in this case, Mnisi tried to mislead the police. Now, the question is, why do we believe the affidavit of Muzi and not the affidavit, the affidavit of Ntanzi and not the affidavit of Muzi? The answer is simple. When you get the affidavit as a police officer, you investigate it, you follow it. And if it leads you to where astray and it leads you to a point where you are not going to solve the matter, you ignore it, you leave it, you follow another evidence. The issue of Muzi was followed, and it was identified that the people that Muzi mentioned, they were arrested. The confession of Ntanzi was followed. It is for that reason that the firearm that was belonging to Mngube and the cell phones were followed. So that corroborates that Ntanzi, when he said Carlos was inside that house, it was correct because it is supported by evidence. So you cannot say because one is supported by evidence, it means the confessions are not true. But as far as it stands, Mnisi and Bongani Ntanzi, they've convicted themselves.
Interesting that the issue of, confession statements is the one that, brings us to this point, because what we know that a confession statement can be only used against the person who deposed it and not against the people that are mentioned in it. So, Bongani, I'm coming back to you with this point. When you look at the role that Mnisi allegedly said he played in that confession statement, does it not implicate him in where he, says, in his role, really? And when you take it to Bongani Ntanzi's confession statement, it basically says the same thing about where he was allegedly standing. That alone, because the confession statement only works against the person who deposed it, do you think that that is not enough?
For me, never. Remember that in court, they say evidence must be tested, right? I was following the case of Jaden, for instance, listening to the investigator being cross-examined. And he said something very interesting when he was cross-examined. He says that the information you are telling me, it will be tested in court. That's the only time you can say it's either right or wrong. At this moment, remember, we bring the two evidence, the two confessions that has already been tested in court. My challenge with it is that if it is free and voluntary, it has to collaborate. It has to. You and I have had the privilege of listening to things that are outside court, such as Longotwan. When you listen to all of those things, we have had privilege of reading articles specifically concerning the things that were said after this incident around 2014. When you listen to everything, and really you can't come here and say the confessions make sense. But I also, please borrow me this time, I want to also attend the issue of the firearm. So I had a privilege of just browsing and going through everything. Around October 2023, if I'm not mistaken, somebody that was testifying, it was Masondo, who said, upon arresting accused number 3, they took the firearm, which was a 9mm, they took it for ballistic test. It came back negative. Since when did the firearm test positive? I will end it there.
Yeah, the answer is simple. Maybe Bongani missed the evidence before court. When you take a firearm to the ballistics, there are 2 tests that are being done whenever you test a firearm. Either you test you're looking for the markings on the cartridge, or you're looking for the markings on the bullet projectile. He is right. It was taken there in 2015. And Ruluse has come to court and gave evidence. He told us that he was looking at the cartridges. Now, there was a bullet projectile. Even Mangena came before court and said there was a decision that was taken that in their IB system, which is an integrated ballistic system that they use to test, they have taken a decision that they are not going to do fuzzy lookups as far as the projectiles are concerned. So the evidence before court says this firearm was only tested with as far as the projectiles are concerned, because at the crime scene, there was no projectile that was found. That is why this firearm was never tested. And the reason there were no projectiles that were found at the crime scene, there are many reasons why the projectiles were not found based on the evidence that is given in court. Now, because it was not tested on those elements, it is for that reason that it became negative.
Gentlemen, last parting shot. What are the prospects of success in this 174 application, Bongani?
There are prospects. However, even if the defense doesn't succeed in Section 174, I still mark my words. They will bring people such as Warrant Officer Makubo and many more. That's where the issue of Absalom Zungu will come in, and we will see the whole case collapsing.
Mabelani?
Yes, once you have made a statement for accused number 1 and 2, is a waste of time for Section 105, for Section 174, because it says if there is no evidence that can lead to conviction. But with the statements on their own confessions, they can be convicted. So there is no Section 174 that is going to come out here. So it will be the waste of time and resources. Bongani is right. We are waiting for Makubo. Makubo is one of the key witnesses for the defense that we are waiting for. But already I can tell you it's not going to help them with anything, because there is a version that was put by Mgomezulu that when Muzi was arrested, Makubo was there. But Makubo has already told us during a trial, within a trial, that he was told that Muzi was arrested on the 19th of March, 2019. So he was not there. So he's not going to assist with anything, just like he failed during a trial, within a trial. Thank you.
Gentlemen, I want to thank you so much for your time. We'll catch up again soon. Interesting views there coming from the voices of the public opinion, or the court of public opinion, and that is Bongani Masuku and Mabelani talking to us about their interpretations of this case. I told you, this particular case is one like no other, because the people here follow it to the T, and it has been quite polarizing. So I want to thank you so much, gentlemen, for your time. All right, that brings us to the end of the show. We know proceedings will resume again on the 7th of August, and this is to know whether or not legal aid will fund that Section 174 application. Until then, have a good one.